Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Friends, you are all well aware that the new major acts, the restructured major acts have been placed before the select committee. The previous CRPC, that is Code of Criminal Procedure, is now called as Bharathiya NAGARIK Suraksha Sanhit 2023. In future we may call it as BNSS Act. There are changes. Previously, in my previous video I told you regarding the zero FIR. Today we are going to discuss the police custody. Friends, you may be well aware that according to Section 57 of the CRPC, the person who is arrested has to be produced before the magistrate within 24 hours. If the investigation is not completed, that means the period of limitation for the investigation is 24 hours. But practically not possible. Why 24 hours is given is basically, please remember, the judicial cognizance will be taken. Of course, if something happens within 24 hours, it can be rectified, it can be noticed. So that's a different topic. Anyway, within 24 hours, you have to produce him before the magistrate. But is 24 hours sufficient time for completion of investigation? Absolutely. In a majority of the cases, no. So, but the interrogation of the person arrested or the investigation is definitely necessary. In such a case, how to get custody? That is police custody. Previously, we used to tell you under Section 167 Clause 2 CRPC, before the first 15 days, you have to file the police custody petition and it may be allowed or it may not be allowed. After 15 days, no, it will not be allowed. This is what CRPC says in the previous CRPC 167. But new act has come. Definitely there will be some changes. That changes are that according to the present new Bharathiya NAGARIK Suraksha Sanhit, Section 187, Clause 2. It says the police custody petition can be filed even after the first 15 days. Even after the first 15 days. So before going deep into the matter, let us understand that there are two types of cases where the remand period is fixed. Number one, more than 10 years, simply to say life, death, imprisonment, punishment where the punishment is offenses where the punishment is more than 10 years. The period of limitation for completion of the investigation is 90 days. For other cases, it is 60 days. If the investigating officer does not file the final report, does not file the charge sheet under Section 173, after the period of 90 days or 60 days as stated above, the accuser has got a default bail, a right to bail, human right to bail. So 90 days and 60 days. Now, please remember, whatever it is 90 days or 60 days, previously according to 167, first 15 days, within first 15 days, the IO has to file the petition for police custody. But here, even after the first 15 days, before the 60 days of 90 days period, before the 40 days of 60 days period, please remember carefully, before the first 60 days of 90 days period, before the 40 days of 60 days period, yes, you can file the application for police custody and you may be granted. So please remember, the police custody should not exceed 15 days. This 15 days you can get in piecemeal also. For example, after 20 days if you file petition, take him for poll trades. After before 60 days, you can take him another time and take him for 10 days. Like that, 50. You can take him in piecemeal also. Anyway, so to conclude, I want to tell you that number one, previously you have to file the petition within 15 days. Now that bar has gone. Second point, you can take him into custody piecemeal. So if you know this much, it is sufficient. So previous section is 167, present section is 187. Like just 20 sections difference. You have to remember these sections. Of course, since we are old people, since we have been conversant with the act, we are able to tell you 167. 187 I may not be able to tell you, but you have to remember. Okay? With this, I am concluding. Thank you.